may have different religions, different languages, different coloured skin, but we all belong to one human race. We all share the same basic values. Kofi Annan.
The Gresham College lecture that you're listening to right now is giving you knowledge and insight from one of the world's leading academic experts. Making it takes a lot of time, but because we want to encourage a love of learning, we think it's well worth it. We never make you pay for lectures, although donations are needed. All we ask in return is this: send a link to this lecture to someone you think would benefit, and if you haven't already, click the follow or subscribe button from wherever you're listening right now. Now, let's get back to the lecture.
In this lecture, we're going to look at the protection of refugees in UK law. As Martin has just said, this is a timely subject with the current debate over the government's appalling scheme to remove asylum seekers to Rwanda. I will argue that even before the recent spate of draconian anti-refugee measures, the UK's asylum system was grossly inadequate and often cruel and discriminatory. I will argue that what we need ultimately is open borders, the abolition of all immigration control. I want to thank David Neal from my chambers, who's an immigration expert. I'm not an immigration expert. I just have strong views on immigration. And David helped me write, in fact, wrote most of this lecture for me, which I've approved. So thank you, David. Terminology. What is a refugee? If you ask a lawyer, they will give you a precise answer to this question. They will tell you that according to Article 1A of the 1951 Convention relating to the status of refugees, the Refugee Convention, a refugee is a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country. Or who, not having a nationality and being outside the country of his former habitual residence, as a result of such events, is unable, or owing to such fear, is unwilling to return to it. But this doesn't necessarily accord with the way people use the term refugee in everyday speech. And when we delve into the history of refugee protection, we will see that the term refugee hasn't always had a consistent meaning. I should also explain how I intend to use the term asylum seeker and refugee. An important concept to understand is that refugee status under the Refugee Convention is declaratory, not constitutive. So a person who meets the refugee definition is a refugee, irrespective of whether a state has recognized them as a refugee. When the state grants you asylum, it doesn't make you a refugee, it recognizes that you are already a refugee. An asylum seeker is, of course, somebody who has applied for asylum. But the terms asylum seeker and refugee are not mutually exclusive because many asylum seekers are, in fact, refugees in law, albeit that they have not been recognized as refugees. Some history. I want to turn to the history of asylum and refugee protection in the United Kingdom. Although refugee law as we know it today is relatively new, the idea that the state should extend protection to people who are fleeing persecution, for example, on political or religious grounds, is not new. There were waves of immigrants fleeing persecution in earlier centuries, such as the Huguenots, the French Protestants who migrated to the UK after 1685, fleeing religious persecution. And, as Alison Bashford and Jane McAdam highlight, an earlier legal concept of asylum developed in the context of extradition. States had the right to refuse to extradite refugee fugitive offenders who were wanted for purely political offences. Now, the reason this early concept of asylum was concerned primarily with extradition, not immigration, is that immigration controls, as we know them, are relatively recent. For a brief time, in the late 18th and early 19th century, the UK did have a system of immigration control. Can you guess when? Can you guess why? Because during the French Revolution, large numbers of French refugees arrived in the UK. And this led to a moral panic about the UK being infiltrated by Jacobeans, who in turn, this led to Parliament enacting the Aliens Act 1793. This was an immigration control statute which regulated the entry and stay of aliens. It was followed by the Aliens Act of 1798, which was a more draconian statute, requiring aliens to obtain a license to reside in Britain. Notably, the preamble of the 1798 Act made reference to the principle of asylum, stating, quote, "And whereas the refugee and asylum, which on grounds of humanity and justice have been granted to persons flying from oppression and tyranny exercised in France and in countries invaded by the armies of France or under their power of control, may be abused by persons coming to this kingdom for purposes dangerous to the interests and safety thereof." These acts were extraordinary wartime measures. A peacetime Alien Act was enacted in 1814, which maintained the Crown's ability to exclude or expel aliens by royal proclamation. This was a temporary act, but was renewed by Parliament every 2 years until 1824. In 1826, it was replaced by the Aliens Registration Act, which, unlike its predecessors, conferred no power to exclude or expel aliens. This, in turn, was replaced by the Aliens Registration Act in 1836, which required aliens to register and obtain certificates, but again conferred no power to expel them. In any case, it fell into disuse. So, from a practical perspective, therefore, between 1826 and 1905, there were no immigration controls as we know them today. The UK had open borders. In fact, the Foreign Secretary, Lord Granville, said in a directive to all British missions in 1852, quote, "By the existing laws of Great Britain, all foreigners have the unrestricted right of entrance and residence in this country. No foreigner, as such, can be sent out of the country by the executive government except persons removed by treaties with other states confirmed by Act of Parliament for the mutual surrender of criminal offenders." This all changed in 1905 with the passage of the Aliens Act 1905. This act was again enacted in response to a flow of refugees, this time Jewish refugees fleeing persecution in Eastern Europe. The 1905 Act was extremely controversial at the time. In part, it was rooted in anti-Semitic agitation against Jewish immigration. As Barnard states, throughout the 1890s and early 20th century, a stark and populist anti-Semitism was at work in the East End of London. And although regularly denied at the time, it was evident in Westminster and Whitehall as well. However, in addition to race and religion, another consideration in play was the regulation of labour. Barnard notes that anti-immigrationists cast Eastern European and Jewish immigrants as a threat to wages and industrial concern. Indeed, some opposed to the Aliens Bill was cast in these terms too. According to Bashford, the successive alien bills and the very principle of immigration restriction were resisted by the Liberals as an attempt to introduce backdoor labour law. And a young Winston Churchill, at the time a member of the Liberal Party, argued that the free movement of people necessarily went along with the free trade of goods. All sounds fairly familiar. The 1905 Act required immigration officers to refuse undesirable immigrants permission to land in the UK. This included those who could not support themselves and their dependents, those who were lunatics or idiots, or those owing to any disease or infirmity appear likely to become a charge upon the rates or otherwise a detriment to the public, or those who had been sentenced abroad for certain crimes. But the Act also contained an important innovation, an asylum clause. Under Section 1, subsection 3D, in the case of an immigrant who proves he is seeking admission to this country solely to avoid prosecution or punishment on religious or political grounds, or for an offence of a political character or persecution involving danger of imprisonment or danger to life or limb on account of religious belief, leave to land shall not be refused on grounds merely for want of means or the probability of his becoming a charge on the rates. Bashford and McAdams argue that this had a much greater significance than historians have generally acknowledged. They state, although it was undisputed at the time, as now, that the states possessed the right under international law to grant asylum to whoever they wished, the statute framed it as a right that individuals could claim to their admission to Britain. Unfortunately, the asylum clause was short-lived. It was removed by the Aliens Restriction Act of 1914, which allowed the King and Council to make orders restricting alien immigration. 1914 was originally a wartime measure, but it was extended for 1 year after the war by the Aliens Restriction Amendment Act of 1919, and thereafter was renewed every year. An aliens restriction order was made in 1920 under the 1914 and 1919 Acts, and remained in force until it was replaced by the Aliens Orders Act of 1953. Meanwhile, in the interwar years, the concept of refugee status in international law developed, with a series of international instruments on the protection of particular groups of refugees, such as Russian, Armenian, and German refugees. The modern refugee definition was introduced by the 1951 Convention relating to the status of refugees, which remains the cornerstone of international refugee law today. Originally, the 1951 Convention was limited to protecting European refugees in the aftermath of the Second World War, and therefore limited the definition of a refugee to those who had a well-founded fear of persecution as a result of events occurring before the 1st of January 1951. This restriction was later removed by the 1967 Protocol to the Convention. The central principle of the Refugee Convention was that of non-refoulement. Under Article 33(1), that provided that no contracting state shall expel or return, that's what refoul means, a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. However, the Convention protection for refugees suffers from a number of serious limitations, to which I shall return later. Meanwhile, the United Kingdom's immigration law was continuing to develop, and here we need to go on a brief digression about British nationality. Before 1949, everyone born within the British monarchy's dominions and allegiances was a British subject. That included not only those born in the UK, but also those born in British colonies abroad. This changed on the 1st of January 1949 with the British Nationality Act 1948, which divided British subjects into two groups: citizens of the United Kingdom and colonies, and citizens of the newly independent Commonwealth countries such as Canada, Australia, and India. CUKCs and Commonwealth citizens were not regarded as aliens and were not subject to immigration control. They retained an absolute right to settle in the UK. But that changed with the Commonwealth Immigrants Act of 1962, which imposed immigration controls on both non-CUK Commonwealth citizens and on CUKs who did not hold a UK-issued passport. Can you guess? Principally black and Asian people from UK colonies. The Commonwealth Immigrants Act of 1968 extended this further, imposing immigration controls on all CUKCs unless they or one or more of their grandparents, parents or grandparents, were born, naturalised, adopted or registered as a citizen of the UK. This act also specifically targeted East African Asians who were CUKCs of Asian extraction who had been resident in either Kenya or Uganda and had had to flee. The Act prevented many East African Asians from settling in the UK and left them with no home to go to. Now, for those of you who want to have a deeper dive into this, I talked about this shameful chapter of our history in an earlier lecture, and time doesn't permit me to go into detail here. From 1973, immigration controls for both aliens and Commonwealth citizens were consolidated into a single statute, the Immigration Act of 1971, which still remains the basis of UK immigration law today. Paragraph 58 of the 1972 immigration rules, made under the 71 Act, broadly incorporate the principle of asylum into our domestic law. However, the Refugee Convention itself was not incorporated into domestic law, and refugees who were not lawfully in the UK had no in-country right of appeal, or if they were refused asylum, their only recourse was that of a judicial review. Now, this changed in 1993 when the Asylum and Immigration Act 1993 provided that the immigration rules could not lay down any practice which would be contrary to the Refugee Convention and gave a right of appeal to those who were refused asylum. A broadly positive change came in 2004 when the European Union's Qualification Directive came into force, which states were required to implement by 2006. This introduced the concept of subsidiary protection, known as humanitarian protection in the United Kingdom, which provides protection to people who are not refugees but are at risk of serious harm on return. It also introduced a number of provisions about the interpretation of Refugee Convention, and it was accompanied by a reception directive which deals with living conditions and support for refugees. And following the UK's exit from the EU, the status of these directives was ambiguous. But it appears from current case law that they are no longer part of UK law, although the UK law and practice on asylum continue to be heavily influenced by these directives. Over the past 20 years, a number of measures have been taken by successive governments, both Conservative and Labour, to deter claiming asylum and make life harder for refugees. One of the primary means used to deter claiming asylum has been to keep asylum seekers intentionally in poverty until their claims were determined. Asylum seekers' entitlement to welfare benefits and housing assistance were curtailed during the 1990s. The Immigration and Asylum Act of 1999 excluded asylum seekers from mainstream benefits and local authority housing altogether, and created a separate system of support for asylum seekers known as NAS support, after the National Asylum Support Service. This remains in place today. Asylum seekers are placed in accommodation provided by private contractors on behalf of the Home Office, often of very poor quality. They are given a minimal level of financial support, currently £49.18 per person per week. In the last few years, many have been left to languish in hotels instead of being transferred to self-contained accommodation, often with entire families sharing a single hotel room, and disabled and vulnerable people being accommodated in grossly unsuitable conditions. Section 55 of the Nationality, Immigration and Asylum Act 2002, passed under the Tony Blair government, prohibits the Home Secretary from providing a person with asylum support if they were not satisfied that the claim was made as soon as reasonably practicable after the person's arrival in the United Kingdom. The intent was deliberately to make asylum seekers homeless and destitute, to punish them for making a late claim. The House of Lords, in a case called Limbuela, however, held that forcing asylum seekers into street homelessness in this way was a breach of Article 3 of the European Convention on Human Rights, inhumane and degrading treatment. More recently, the current Conservative government has started housing asylum seekers in former Ministry of Defence barracks and on the Bibi Stockholm barge. Again, as a deliberate deterrent measure that can only be described as wanton cruelty. In the case of NB, the High Court found that the accommodation at the Napier barracks was inadequate for an asylum seeker's needs, and that the process for identifying vulnerable asylum seekers who were unsuitable to be accommodated there was also inadequate. In December 2022, an Albanian asylum seeker, Leonard Faruku, who was accommodated on the Bibi Stockholm, tragically took his own life. But understand this, it isn't just poor living conditions that have been that has been used to make life harder for refugees. For many years, many asylum seekers were subjected to the detain fast track process, an accelerated decision-making process that took place while they were being held in detention and on which the vast majority of claims were refused and appeals dismissed. Eventually, the detain fast track was successfully challenged by the NGO Detention Action, with the Court of Appeal holding in 2015 that it was structurally unfair and unjust. The Immigration and Asylum Act 1999 introduced the power, now found in the Nationality, Immigration and Asylum Act of 2002, for the Home Secretary to certify asylum claims as unfounded, so that the asylum seeker could not appeal the refusal of their claim from within the UK. In recent years, this draconian measure has been used particularly often against Albanian asylum seekers. Another weapon in the Home Secretary's arsenal has been the removal of asylum seekers to supposedly safe third countries. Until the end of the post-Brexit transition period on the 31st of December 2020, the United Kingdom participated in the EU Dublin regulation arrangements, under which asylum seekers could be returned from the UK to other European countries which were deemed responsible for dealing with their claims. The problem was that some other European countries were habitually leaving asylum seekers destitute and street homeless. In 2011, MSS against Belgium, the European Court of Human Rights, found that the removal of asylum seekers to Greece under the Dublin arrangements breached Article 3 of the European Convention on the grounds that asylum seekers in Greece were living in conditions of destitution and homelessness. More recently, in the case of SM, the upper tribunal accepted that some particularly vulnerable asylum seekers would be at an Article 3 risk in Italy. Another issue was not all European countries handled asylum seekers acceptably. In Ibrahimi, the High Court accepted that asylum seekers being returned to Hungary would be at risk of onward refoulement to countries where they faced persecution. The UK ceased to participate in the Dublin arrangements when the transition period ended. With the increase in small boat arrivals, the Conservative government, as is well known, took drastic action. It negotiated the Migration and Economic Development Partnership, that's the MEDP, under which asylum seekers were to be sent to Rwanda, which would be responsible for deciding their asylum claims. Asylum claims by individuals who had claimed asylum in supposedly safe third countries or who had passed through safe third countries and whom the Home Office considered ought to have claimed asylum there were to be held inadmissible and not considered in the United Kingdom. At the same time, Parliament passed the Nationality and Borders Act of 2022, a compendious statute which, among other things, put the new inadmissibility rules on a statutory footing, changed the United Kingdom's interpretation of the Refugee Convention in several respects, expanded the criminalisation of asylum seekers and provided for recognised refugees to be treated less favourably if it was deemed that they should have claimed asylum in a safe third country, with a shorter period of leave and no right to family reunion. The latter policy has since been abandoned. As is well known, the Rwanda scheme was successfully challenged in the courts. The European Court of Human Rights granted an interim measure under Rule 39 of the rules on the eve of the first flight taken off. As a result, no one hitherto has been sent to Rwanda. In the High Court, the lawfulness of the Rwanda scheme was upheld, but several individual claimants still succeeded in their judicial review claims. The Court of Appeal allowed the appeal and held that the Rwanda scheme was unlawful on the basis that there was a risk of onward refoulement to Rwanda, from Rwanda to countries where the asylum seekers were at risk of persecution due to the inadequacies of the Rwandan asylum system. The Supreme Court dismissed the Home Secretary's appeal and confirmed that the scheme was unlawful. Meanwhile, Parliament passed the Illegal Migration Act of 2023, an exceptionally draconian statute which, if and when it is brought fully into force, will give the Home Secretary a duty to remove from the United Kingdom any adult who meets the Act's 4 removal conditions, regardless of any asylum or human rights claim they may make. The first removal condition encompasses, amongst other things, those who entered the UK without leave, entered with leave obtained by deception, entered in breach of a deportation order, or arrived without entry clearance when they were required to have it. That, my friends, covers the vast majority of asylum seekers. The second removal condition is that they entered or arrived on or after the 20th of July 2023. The third removal condition is that they did not come directly to the United Kingdom from a country where they face persecution. The language of coming directly comes from the Refugee Convention, in the context of which it has previously been held that a person may have come directly even if they briefly transited through safe third countries. But the Act seeks to head this off by providing that a person who has not come directly if they passed through or stopped in a safe third country. And the fourth removal condition is that they require leave to enter and remain and do not have it. Unaccompanied children are not subject to the duty to remove while they are children, but will be subject to that duty when they turn 18. For most asylum seekers, the Illegal Migration Act only allows them to be sent to a safe third country, not to their own country. They can make a serious harm suspensive claim if they claim to be at risk of serious harm in the third country, with a right of appeal to the upper tribunal if it is refused. However, there is an exception for nationals of certain states, which include states of the European Economic Area and, controversially, Albania. Nationals of these states can be returned to their own countries and cannot make a serious harm suspensive claim to stop their return. This is a clear breach of the Refugee Convention, given that many Albanian asylum seekers are in fact at risk of serious harm on return. Now, the government has lost the Rwanda case in the Supreme Court. They have, as is well known, introduced the Safety of Rwanda Asylum and Immigration Bill, which is currently before Parliament and which seeks to overturn the Supreme Court's judgment by statutorily deeming Rwanda to be a safe country. Therefore, we can see that the story of UK refugee protection has often been one step forward, 2 steps back. The last 2 decades have been a series of increasingly draconian anti-refugee measures. Against this backdrop, I now want to turn to look at the international legal instrument which is at the heart of these debates, the Refugee Convention. The Convention, while a groundbreaking measure, is severely limited in its protection afforded to refugees. This is for a number of reasons. First, the refugee definition only encompasses victims of persecution. Contrary to popular usage, not everyone fleeing a war zone, for example, is necessarily a refugee. The fact that someone is at risk from indiscriminate violence does not by itself make them a refugee, although it may entitle them to humanitarian protection. Similarly, the fact that a person would be destitute on return does not in itself make them a refugee, although it might be relevant to their refugee claim if, for example, their poverty would put them at risk of human trafficking. Secondly, not all victims of persecution are refugees. The persecution has to be inflicted on account of one of the 5 Convention reasons: race, religion, nationality, membership of a particular social group, and political opinion. Membership in a particular social group has been construed relatively widely to encompass, for example, gender and sexual orientation, but the concept does have limits. This means that a person can be at risk of persecution, even appalling persecution on return, and yet not be entitled to the protection of the Refugee Convention. This means, for example, that victims of criminal gangs or armed groups are not necessarily entitled to refugee protection. It depends on the motive of their persecutors for persecuting them. Today, in a UK context, this matters less than it once did, because a person who's at risk of serious harm on return, but who cannot establish that the harm they will suffer is on account of a convention reason, is normally entitled to humanitarian protection. But before the introduction of the humanitarian protection concept, it mattered a lot. At times, this has led to appallingly harsh decisions. In the American case of Campus Guardio, a woman who had been raped and had seen her male family members hacked to death with machetes was denied asylum because she failed to show that the persecution she had suffered was for a convention reason. I should say little about the definition of particular social group. 2 basic approaches to this concept have emerged from the case law. One is that such a group must share a common characteristic which is either immutable, in that it cannot be changed, or fundamental, in that the individual should not be required to change it. The other is that such a group must have a distinct identity in society concerned, such that they are perceived as different by that society. The Qualification Directive incorporates both these approaches. Now, for some years, the Qualification Directive was interpreted by the United Kingdom courts as requiring that a proposed particular social group must meet both the immutable characteristic and the distinct identity tests. But in the landmark case of DH, the upper tribunal held that they could be read as alternatives. Only one or other need be satisfied. This was a progressive decision that significantly widened eligibility for refugee status. But from the 28th of June 2022, Parliament has now reversed DH by statute. And in the Nationality and Borders Act 2022, it is now once again necessary to meet both limbs of the test. A third limitation of the Refugee Convention is that it excludes from its protection those who are considered undeserving. Article 1F of the Convention excludes from refugee status those who've committed crimes against peace, war crimes, or crimes against humanity, those who've committed a serious non-political crime outside the country of refuge, and those who are guilty of acts contrary to the purposes and principles of the United Nations. Article 33, subsection 2 of the Convention provides another very significant limitation on refugee protection. A refugee who's committed a particularly serious crime and is a danger to the community or is a danger to the security of the host state is not protected from refoulement. Such a person is still technically a refugee, but the Convention does not prevent the host state from expelling them. The United Kingdom has adopted a very harsh interpretation of these provisions. Section 72 of the Nationality, Immigration and Asylum Act 2002 introduced a statutory presumption that anyone sentenced to a 2-year imprisonment has committed a particularly serious crime and is a danger to the community. The Nationality and Borders Act of 2022 has now reduced this to 1 year. This does not mean that the UK is able to deport criminals who face persecution on return. Article 3 of the European Convention on Human Rights provides an absolute protection against torture and inhuman or degrading treatment or punishment. If there is a real risk that that person would be subject to such treatment on return, they cannot be removed or deported regardless of what crimes they have committed. But in such a case, the UK's approach is normally to give such individuals restrictive leave to remain in the UK for 6 months at a time, subject to significant restrictions on their freedom, in contrast to the 5 years leave to remain normally granted to refugees. The fourth, and perhaps most important limitation on the Refugee Convention is that it doesn't require states to provide safe and legal routes to flee persecution. When a refugee gets to the United Kingdom, they are protected by the Convention. But before they get here, they enjoy no such protection. The United Kingdom has deliberately made it as difficult as possible for refugees to reach our shores. The few safe and legal routes that exist are limited to particular nationalities and groups. They are not available for most refugees. Most refugees come from countries whose nationals are treated by the United Kingdom as visa nationals, meaning that they cannot simply get on a plane to the United Kingdom. They must apply for and obtain entry clearance in order to come to the United Kingdom. Due to the UK's regime of carrier sanctions, airlines will not carry a visa national who does not have a visa. And there is no such thing as a refugee visa. Therefore, unless you qualify for one of the few available safe and legal routes, you cannot apply from abroad to come to the United Kingdom as a refugee. You can only claim asylum once you get here. This means that someone who is being persecuted and needs to flee their country has very few options. If they have the financial resources to do so, they might be able to obtain a UK visa in some other category, such as visitor or student, through deceiving UK officials as to their intentions. They can claim asylum once they arrive. But for most refugees, that option is inaccessible. Paying smugglers to bring them illegally to the UK is simply the only option available to them. Significantly, the United Kingdom criminalises both of these routes of entry. A person who obtains a visa by deception commits the offence under Section 24A of the Immigration Act 1971. A person who enters the UK illegally commits an offence under Section 24 of that Act. The UK's criminalisation of refugees was significantly widened in 2022. Previously, in the 2021 case of Kakai, it held that if an asylum seeker crossing the English Channel in a small boat intended to arrive at an approved port of entry and claim asylum there, then they would not commit an offence under Section 24 of the 1971 Act. And anyone who assisted them, such as another asylum seeker or somebody who steered the small boat, would not commit the offence of assisting unlawful immigration under Section 25. However, the Nationality and Borders Act of 2022 changed the law so that arriving in the UK without a visa, when one is required, is now a crime. Article 31 of the Refugee Convention is supposed to bar states from penalising refugees on account of their illegal entry or presence. But in domestic law, Section 31 of the Immigration and Asylum Act 1999, which provides refugees with a defence to some criminal charges, does not apply to offences of arrival without leave or assisting unlawful immigration. As such, if you want to come to the United Kingdom and claim asylum here, in general, you have no choice but to commit a crime. However, the typical argument made by politicians to justify anti-refugee policies goes like this. Those refugees who come over to the UK, overland, and who have travelled through a number of ostensibly safe European countries on the way here, they should have claimed their asylum in one of those countries rather than travelling on to the United Kingdom. They argue that someone who travels on to the UK rather than claiming asylum, say in France, Italy, or some other European country, is travelling by choice, not necessity. There are a number of reasons why that is a bad argument. I will list them. The first is that many refugees have no choice in their destination. Refugees seeking to flee to a safe country often have no choice but to rely on unscrupulous criminal gangs. In many cases, the gangs give the refugee no choice as to their destination. In some cases, once the refugee arrives, they will be exploited by the gang, using the pretext that they owe a debt for their journey to the United Kingdom. Human trafficking of refugees into labour exploitation, forced criminality, and sexual exploitation is, my friends, rife. And even where a refugee has not been trafficked, it does not follow that the smuggling gang will give them a choice about their destination or even tell them where they are going. Second, many European countries, to be blunt, treat refugees appallingly. France, for example, regularly leaves refugees, including children and families, homeless and destitute on the streets, which was condemned by the European Court of Human Rights in the case of MK and others against France in December 2022. Nor do all of the supposedly safe European countries operate an adequate system of asylum adjudication. As we've already heard, for example, in the case of Ibrahimi, asylum seekers successfully challenged their removal from Hungary on the basis that they would be at risk of refoulement to countries where they would be persecuted. Third, which is equally important, is that it is plainly unreasonable to expect those countries on the southern and eastern periphery of Europe to host all the refugees travelling into Europe from elsewhere. Britain is a very wealthy country. We have a moral obligation to shoulder our fair share of the global refugee crisis instead of leaving it to other European countries to do so. So, the argument that refugees should claim asylum in the first safe country is a spurious one and a poor excuse for punishing refugees. We've looked at 4 limitations of the Refugee Convention. I want to turn to a 5th limitation, which is that the Convention does not actually give refugees a right to be granted asylum. It only prohibits refoulement to a country where they face persecution. So, as we've seen, it doesn't stop states from expelling refugees to supposedly safe third countries. Finally, I want to turn to a 6th limitation, which is the inadequacy of the process by which the state decides whether a person is or is not a refugee. When decision makers are seeking to determine whether an asylum seeker is credible, that is, whether they are telling the truth about what has happened to them, the methods they use to distinguish truth from falsehood are demonstrably unreliable. Research has shown that asylum decision makers have unrealistic expectations about what asylum seekers should remember. Decision makers often treat inconsistency in a person's account as evidence of fabrication. But in fact, inconsistencies routinely arise in the accounts of truthful witnesses. And this is exacerbated by the fact that many asylum seekers suffer from mental health conditions which can affect memory. Similarly, in deciding whether asylum seekers are at risk of persecution and whether they would be adequately protected by the state against persecution from non-state actors, Home Office decision-making is often unreliable and influenced by political considerations. For example, my colleague David Neal has shown that the Home Office guidance to caseworkers about how to decide Albanian claims is unreliable, misleading, and based on cherry-picking the country's evidence. And a report by former Chief Inspector of Borders and Immigration, coincidentally also called David Neal, but without an E on the end, revealed shockingly that as part of a recent government initiative called Operation Bridora, a decision had been taken at ministerial level that no more than 2% of Albanian claims should be successful. Did you hear me? How can you make that decision before you've heard the claims? Unbelievable. This appalling decision-making comes at a terrible human cost. A person wrongly refused asylum may be removed to a country where they face death or serious ill treatment. Or if not removed, they may become street homeless, be exploited in dangerous illegal work, or driven into the arms of human traffickers. Conclusion. What's the solution? The bare minimum that is required is to establish safe and legal routes for refugees to come to the UK without a restriction on which nationalities are eligible and without cap on numbers. That is the only solution which will stop small boat crossings and will end the tragic loss of life in the Channel. But I think we need to go further. The Refugee Convention, while a vital humanitarian measure, is simply not enough. We need to return to the pre-1905 position and abolish all immigration controls. We need open borders. That, my friends, is the only solution that will ensure that everyone who needs the UK's protection is able to obtain it. You see, I argue the UK is one of the world's wealthiest countries and has far greater resources and resilience than many countries which host far greater numbers of refugees. The commonplace counter-argument is that open borders would overwhelm the UK's infrastructure and services, would lead to fewer jobs and lowering of living standards for the British workers. There are two answers to that. First is it doesn't have to be like that. As I made clear in my last lecture on wealth inequality, our current neoliberal economic model and depleted state capacity is deliberate. It's a deliberate political choice, not an inevitability. If we had the political will, we could marshal the UK's resources to provide a decent standard of living to everybody, citizens and immigrants alike. The wealth of billionaires and use that wealth to provide housing, healthcare, infrastructure, and a basic universal income. And refugees would be a help, not a hindrance. Refugees, you see, bring huge benefits to the UK's economy and society. The second answer is that even if one assumes that open borders would lead to a lowering of living standards for British people, this argument assumes, and what it needs to prove, namely, that British people are more important than foreigners. And I don't accept that. I hope one day we will recognise that discrimination on the basis of nationality is just as iniquitous and as discrimination on the basis of race, gender, or sexual orientation. No one needs to be consigned to a lesser status because of an accident of birth. In short, open borders, I believe, are the only solution. Let me finish with two quotes. Compassion for refugees is not just a moral imperative, it's a testament to the strength of our humanity and the depth of our empathy. And my final quote comes from Audrey Hepburn. As you grow older, you discover you have two hands, one for helping yourself, the other for helping others. Thank you.
Thank you very much, Leslie, as ever. Very thorough and searching. Early on in your lecture, it talks about the state essentially behaving cruelly.
Yeah.
And the state, you listed sequentially through your talk, cruel acts, which I think anyone listening to it would recognize as cruel. When does the situation arise that a state acting with such cruelty can itself be brought to court for cruelty, and whom by, if that were possible?
Well, firstly, individuals who are, suffering the cruelty themselves. So, a potential asylum seeker, it's possible that they may bring a claim. Generally speaking, that claim is by way of judicial review, or various challenges or appeals under the various legislations that I've listed. And remember, it's been a game of cat and mouse with immigration laws. The courts giveth with one hand, Parliament seeks to taketh away with the other hand. And that's what we've been seeing with, particularly with our current government, with the to-in and fro-in with the Rwandan legislation. Secondly, NGOs have been very instrumental in bringing some of these challenges on behalf of various groups, and we've seen that. So as interested parties to litigation. So individuals and NGOs primarily.
So before I open it up to the floor here, if you accept your argument that England's open borders would be a good thing, is it possible to do that as a single country? Or does the ability to have an open border rely on, let us say, everyone else in Europe having one as well, so that we can come in and out as we wish?
Well, we were closer to an open border situation within the European Union, and we decided to take ourselves out of that. I know the argument that I will be met with. It's generally, well, we can't do it on our own, because if we do it on our own, we're going to be swamped. Everybody will come here. But that doesn't deal with the fact that somebody has to start. And as I said in the lecture, I don't think that we are a particularly poor country.
Yes. Thank you very much. It was a very elucidating lecture. Not something I know an awful lot about, so apologies if this is somewhat of a simple question. But it seemed to me that from your description of the law and the attitude of politicians, there seems to be particular discrimination or particular dislike of asylum seekers as a subsection of immigrants. I suppose, firstly, is that a fair characterization of the situation? And secondly, if so, why do you suppose that is? Why is it that asylum seekers are discriminated against so heavily as a group of immigrants?
Thanks for the question. I think that the short answer is, and we see this time and time again, and we saw it when I was talking about the anti-Semitic legislation that was introduced in the early 20th century. We look for scapegoats. We look for excuses. We look for people to blame. If it's not trying to get working people to turn on themselves, it's to get working people to turn on somebody to blame for situations that aren't the cause of working people. So I think a lot of this, and it's really interesting, if you look at the moral panics that have been created particularly in certain branches of the media at particular times. Look at the moral panic that there was in relation to Brexit. And the irony is, do we all remember that poster with, that huge line of people who weren't even from the European Union? But it's trying to get people, ordinary people, to hate, to dislike, to blame somebody other than themselves as a diversionary tactic in relation to problems. And I think immigrants, I think refugees are an easy target, very easy target. Hey, but that's just me.
It's a popular question from online. Do you think it's going to get better when Labour come into power?
What's interesting is we know that Labour is just as influenced by certain populist views in terms of trying to achieve and hang on to power. And I say that because, and I hope my lecture was balanced in the sense that I wasn't saying this is all the Tories, because it hasn't been. The Labour government, successive Labour, we haven't had that many Labour governments, but the point is, the Labour governments that we have had, since the pre-war years have been just as bad as Conservative governments, save for the fact that under Labour government the Human Rights Act was introduced. So I would hope that Labour would be more progressive, but I'm not holding my breath.
Is there any more questions from the floor here? We have one at the back, in fact two. Let's take it in turns.
Oh, hi, thanks very much. What a fantastic lecture and food for thought for the future. If Labour do get in, and I share your views that I'm not sure that much will change really. You're talking about trying to get the new government to try to renationalise banks, which I think is probably improbable. What I think is much more achievable is trying to compel Facebook and Google and Amazon to actually give profits to this country. I'm pretty sure that if this government or any other said to Jeff Bezos, currently worth a rather paltry 130 billion, you either pay your tax or we close you down, I'm sure he would.
I agree.
So it's one just behind you as well.
Hi, again, thank you. I feel like, not only was it was very kind of factual in terms of, not only your opinion came across, but the fact that we've learned so much about the appalling and consistent way Britain legislates against this. So not to kind of diminish that, but just wondering if there is a more positive note. Is there anywhere, obviously not with open borders yet, but that you think maybe it could be a step towards Britain doing something a little bit better, that another country kind of has legislature that you think doesn't just keep leaning towards more cruel and more appalling and more discriminatory? Do you have any examples of that?
So I do think that particularly, the first thing to say is no country is perfect, okay? But I do think some of the countries in Northern Europe, I'm talking about some of the Scandinavian countries, their policies were a little more progressive in terms of the numbers and the peoples that they were allowing in, which we could take a leaf out of their book. It comes back to on the small, windy, grey islands that we live on, we're very, very protectionist, and I think it comes back to that point I was making earlier. Why should we have a situation where we have, as a bare minimum, no safe legal routes for genuine asylum seekers? We just don't have any safe legal routes. And if you stop and you analyse that, you can see the unfairness. If you're saying you need to claim asylum in the first safe country you pass through, well, that's going to be the countries of southern Europe, generally speaking, isn't it? And if it's countries, why should they bear the disproportionate burden? And it's now that we've pulled out of the Dublin Convention, it's going to get worse. Well, actually, it has got worse for us because, with the small boats crossings, we can't even say, as a union, because we're no longer part of the union, there should be a fair distribution amongst the 28 previous European Union states. So anyway, it's a long, rambling answer to your question. I'll just say perhaps we could take a leaf and look at how some of the northern European countries first dealt with their influx of refugees. I think
I'm really sorry, but I'm going to have to stop the questions there, not because I want to, or because we're running out of interesting things to talk about. Of course, Leslie's got to go and deal with another case, having done all of that. Leslie, thank you very much for a fantastic lecture.